Doing good, doing good.
All right, good. We want to welcome and thank everyone for joining us for our monthly financial wellness ministry conversation. If you're watching on Facebook, YouTube, or Twitter, if you could do me a favor and go ahead and share the post, I would be extremely appreciative. Again, if you're watching on Facebook, YouTube, or Twitter, if you go ahead and share the post, I would be extremely appreciative. If you're watching on one of those platforms and you'd like to participate on this virtual platform, pinned to the top of the comments is a link for the Zoom platform. Just click that link and you can come and join us on this platform. I'm going to now place it in the hands of our financial wellness ministry coordinator at Greater Bethel, Kiera Hall.
Hello, everyone. So today, we are going to be talking about estate planning, and what I'm gonna do is I'm actually gonna kickstart us off with a little bit of dialogue of kind of like the pitfalls of not doing the estate planning, and then I want to share a scripture as well. So I'm going to share my screen and we'll start off with scripture. Let's see. Okay, so one of my favorite places to go um is openbible.com, but I have like seven Bible verses that deal with legacy. Because I think sometimes as Christians, um, well, it just depends on how like what you were taught, but sometimes there's all type of conversation around legacy and estate planning, and sometimes it could be a topic that there's just a lot of you know lack of clarity about, or even is it really important? I know something that someone just said to me yesterday was, well, I feel like Jesus is coming back soon. So this kind of feels like a waste to like even do all this stuff. Like, why should I, put away for retirement and, um, just get all this stuff. Like, I know it's important, but it kind of seems just like a waste because I really feel like Jesus is coming back. And when we were in this conversation, one of my other friends was like, I feel you, but my great grandma was saying that in her time too. They've been saying that for a long time. And I told her, I said, I feel you too. I said, there's some crazy stuff going on in the world, like just crazy. It definitely feels like end times. But I was like, I don't think I've ever met anybody who was disappointed that they were prepared. Like, I say, worst case scenario, Jesus comes back next year and you know um and you never use the life insurance or retirement or any of the stuff that you planned, the will, the trust. And I was like, I don't think you'll be mad. I don't think if Jesus came back you're gonna be sitting here thinking like, man, I wasted my money on I wasted my money on that trust, or I wasted my money. And so I just want to throw that out there and address that, when it comes to estate planning, keep an open mind and know that um I don't think you'll be mad that you did it. Like, even if it is the end time. And so um I want to share that, and then I'm going to share, and I'm super excited cuz I'm sharing a couple of scriptures. But Sarah is a friend of mine, and she is an amazing attorney, and she's funny too. I'm not sure if she's going to be bringing any of her comedy on tonight. But she is so funny to me. I always crack up. And so I cannot wait for y'all to learn from her. um, and so she is an attorney with the Tony Law Firm. Oh, and before I do an introduction to her, I got to share that scripture that I told you all that I would share real quick. And so, of course, my favorite scripture, Proverbs 13:22, a good man leaves an inheritance to his children. And so this Bible verse is really just about legacy and, keeping our life goals and our vision and our future like front and center. And when we're choosing how to, use our money today, um and choosing like, okay, what do we want now versus what do we really want later, and realizing that, something that might feel good right now in the moment won't last, like leaving a legacy of like purpose and generational wealth for years to come. And so an inheritance, it's not limited to money. An inheritance also includes godly character qualities like integrity and trustworthiness. And then when you combine like financial inheritance with wisdom and character, this just makes sure that the next generation will manage their blessings God's way and for his glory for a long, long time. And so Proverbs 13:22, I love that scripture. There are more, but I won't go over them because I really want to I want to hear Sarah's presentation. And so she is gonna give us some wisdom, and something I'm super excited about is when me and her got to sit and just eat lunch together and I learned about what her firm was doing. Something that I noticed was like, wow, like your services are really affordable. Like I've seen attorneys to where it's really expensive for like the same type of paperwork, to get the stuff done. And so I thought that was amazing. And she was just like really down to earth. I didn't feel like, even though she's a lawyer, I didn't feel like she was talking what I like to call lawyerese. I felt like she was just talking regular, and I could understand everything that she was sharing, and I felt like it was really beneficial. And so I was like, I really want Sarah to come and talk. And so Sarah, we have live audience on Zoom. It's broadcasted on Facebook and YouTube as well, just so you know. So we'll pay attention to like the other media chats if anybody has questions. But I want to turn the floor over to Sarah. She's going to give us a presentation and just help get us clarity and education. And then at the end, she's going to have some Q&A. And so if you have any questions about estate planning, like trust and wills, or why this, or probate, and just anything with estate planning, like that is what she is the expert in. And now is the time where you can actually get these questions answered if they're not already answered in the presentation. So we'll listen to the education first, and then we'll have a Q&A at the end. And this is also recorded. And if you're watching right now, please go ahead and share to on your social media so more people can get this information. Also, remember, like my dad said at the beginning, there's a link to where if you want to come from watching like a live to come on the Zoom with us, you're welcome to come on the Zoom too. So, Sarah, it is so good to see your beautiful face. Everybody, please help me welcome Sarah Dix. She is going to come and talk to us about estate planning.
Wow, that was such a warm welcome, Kara. Thank you. So, yes, I'm an attorney, a probate and estate planning attorney here in Gainesville. I graduated from Levin College of Law, also here at UF. And I'm a relatively new attorney. I don't know if you can tell, but I work for a very, very experienced attorney. So that is where I get all of my knowledge from. So without further ado, the easiest way I can think to explain why people need estate planning is what happens when you don't do it. So, you know, there's a lot of misinformation out there. There's a lot of myths. So first, I just want to start by explaining what happens if you don't do your estate planning. So it doesn't automatically mean that the state gets all of your assets. That's not what it means. There are, laws on the books specifically for when people don't have a will, but your estate will be subject to probate if you have any assets that are in your name alone. So any place that doesn't have a home, so bank accounts, vehicles, like real estate, if there's not someone with survivorship, joint tenancy rights on the asset, or pay on death beneficiaries, usually on accounts, then that asset will be subject to a very complicated, long, expensive, drawn out process called probate. So, um, why don't we want to do probate? So, probate, the state doesn't get all your money necessarily, but the lawyers do. So, um, typically, estate planning is a way to circumvent that whole process. So, we set up a trust, all your assets get put in the trust. You have a successor designated, a successor trustee who manages your assets after you're gone, and it survives you. But if you don't have something like that set up, you don't have pay on death beneficiaries, then the court has to basically decide where your stuff goes. Now, in Florida, if you don't have a will, there is a statute that says where your stuff goes. So if you die without a will in Florida, who inherits what you leave behind? So the order of succession is if you're married, your spouse will get everything, or at least half. So if you have children together, the spouse will get everything. If you have children outside of that marriage, it's 50-50. So half will go to your spouse, half will go to the children that is not of your spouse. And that, I guess, is just to protect the rights of children who have a different parent. I'm not sure. That's just what the law is. So if you're not married, your estate goes to any children that you have. And if you don't have children, it'll be passed to your parents. If no parents, then sibling, no siblings, then extended family, and so on. If the court runs out of heirs, if the court can't find any heirs and you don't leave a will behind, that is when the state will take your money. So you have a certain amount of time to claim those assets before they escheat to the state, is what it's called. So you definitely don't want that to happen because the state already gets enough of all of our money. So what is estate planning? So estate planning is basically the way that you avoid having to go through all of that rigmarole. Now, you're not going to have to do it. Your wife or your husband or your children are going to have to do it. And it is a pain in the butt. So lawyers' fees for probate are about 3% of the value of the estate. So if you leave behind an estate that's worth $1 million, your attorney gets $30,000 out the gate. Standard. It's 3% across the board. It is a very common percentage to take from the estate. Give the lawyer a lot of money. Compare that with a comprehensive estate plan at our office is about $1,600. So, I mean, you can't avoid us forever. You can either, do some planning on the front end or pay the price on the back end. So, estate planning is the anticipating and arranging of the management and disposal of a person's stuff during the person's life in preparation for their future incapacity or death. So where your stuff goes when you're gone. And, it doesn't have to be a trust. I just did a plan for a woman that, she didn't need to do a trust. It depends on the assets. So she was able to get away with just doing like a will and then designating pay on death beneficiaries on all her accounts. And that took care of all of her assets. Now, if you own your own business, if you own real estate, that's where, if you have minor beneficiaries, that's where you really need to lean more towards doing the trust. So a trust is basically just this amorphous concept that's put down on paper saying you're creating this place for your assets to live, essentially. So, you make this trust. The trust itself is not just a list of the assets. The trust is rights and responsibilities of people who you've designated to manage all of that. So what the trustees' powers are, how assets will be distributed to the beneficiaries, if it's a lump sum, if it's just installments over time. You really have control when you put together a revocable living trust. So that is the most common tool that people use to avoid probate. So the documents that we offer is the trust. So again, that's used to avoid probate and protect the privacy of trust owner and beneficiary. So it is a private document. It's never recorded with the court. That is a selling factor for a lot of people. There are certain tax and creditor benefits to getting a trust. And then, of course, there's the last will and testament. So if you do a trust in tandem with a last will and testament, we call that a pour-over will. All the pour over means is that if you forget for whatever reason to move all of your stuff into the trust, that pour over provision in the will move it over on your death. So everything ends up in the trust to be distributed how you described. So if you want one child to get everything and you don't like any of the other children, you are fully allowed to just give everything to one. Now, you cannot disinherit your spouse in Florida. There are certain rules against that. It is frowned upon. You can write it all you want in your will, but the spouse will be entitled to at least a third of your estate by law. So just be aware of that. You can write out your children, but be aware of writing out your spouse. All right, so next, power of attorney. So that's another document that we offer. Really, really important document to have if you are ever in a situation where you are in a coma or you have advanced dementia or Alzheimer's or something like that, where you are no longer legally able to make those decisions. They act in a wide range of legal, financial, and business matters and remains in effect if you become incapacitated. So that's the durable part, right? So that's the whole point. Why would you want a non-durable power of attorney when the whole point is if you become incapacitated, you need help from other people, whether that's paying your bills, buying, selling property, making investments, filing tax returns, applying for government benefits like Medicaid. The list goes on and on. Now, if you don't have that and you are in that situation, the court has to appoint a guardian. Now, you talk about expensive. Probate is small potatoes compared to a guardianship that lasts forever, lasts the rest of your life. You have to do plans and accountings every single year. It is a pain in the butt. It's hard to find attorneys who even want to take guardianships anymore. We used to do them. We don't offer them anymore because they are just such a big deal. So next up is a healthcare surrogate. So that's kind of similar to the power of attorney. If you're in a situation where you can't make your own healthcare decisions, then it authorizes someone to make medical decisions for you on your behalf. So like choosing hospitals, doctors, what course of treatment to take, that kind of thing. That's not to be confused with the living will. That is a separate document. That is the end of life, pull the plug document that people think the healthcare surrogate has the authority over it. And actually that decision is made by your doctor. So it outlines your end of life healthcare preferences if you're unable to communicate them, chiefly that if you are in a terminal condition and two doctors agree there's no hope, no medical probability that you're going to survive, to discontinue artificial, life-sustaining care and let you pass naturally. So it's also called an advance directive. A guardianship designation, again, not to be confused with a guardianship. So the guardianship designation is when you have minor children and you're selecting basically who you would like to raise your child if you and your spouse die or whoever their other parent is before they reach the age of majority. So it's very important to have that if you have minor children. So, but that's not all. Some people only have real property. So if you have pay on death beneficiaries on all of your, checking, savings, stocks, whatever it is, and you have real property and you have nothing else, you don't have to do a trust. You can just do an enhanced life estate deed and that will take care of your property for you. So enhanced life estate deed is also called a ladybird deed, and it immediately transfers real property to a beneficiary upon your death. It is super easy, super cheap. It is my favorite estate planning tool because it is so cheap and easy. But you retain all your rights in the property when you're alive. You can sell it, you can mortgage it, you can do whatever you want, you can destroy it. You are not liable to the remainder men, so your beneficiaries. Now, once you die, though, all they have to do is record the death certificate and that property passes automatically. So it is super convenient, and I really recommend it if you own real property. Okay. Now, if you go the trust route, you don't need the ladybird deed because you were going to put that property in your trust. Okay. And then some other documents we do, prenuptial, postnuptial agreements. Everybody knows what that is. A personal services contract is, more what my boss says. So Mr. Tony, that's Medicaid planning. So it's an agreement between a caretaker and the elder to provide him or her with personal care services for his or her lifetime. It's essentially a spin down type thing so that you can qualify for Medicaid. Okay. And of course, I'm going through this pretty quickly. So if you have any questions about this, please be sure to ask during the Q&A or just email me for more information. Okay. All right. So the goals of estate planning, like I said, probate avoidance, you don't want to have to do the expense. It lasts 1 to 2 years. There are different kinds, whether you have a will, whether you don't have a will, if your estate is under 75,000 or not. But it can be very expensive, very time consuming, and very emotionally draining. So no one works harder than the personal representative. I say that all the time. We're just the paper pushers. The personal representative, so the administrator, your son or daughter, your spouse, they are the ones that have to go out and consolidate all your assets and open the estate account and, deal with the creditors, and it's a nightmare. I have never heard anyone say that probate was a good time. But another reason is just control. So a lot of people have feelings of powerlessness when they're reaching the end of their life. Of course, you don't, maybe necessarily know what's going to happen, or you're nervous and you feel like you don't have control, but you do. So if you do your estate planning, you determine who gets what, how much, when. Control over successors and designees. You minimize costs that your families have to pay to lawyers, and minimize taxes. You ensure peace of mind for your family as they transition to a life without you. And that is not something they want to have to be dealing with while they're grieving you. So, and then my personal favorite is give last minute throw punch by disinheriting heirs that you don't like. So if you have someone in your family that you just desperately hate, and under the intestacy statute, so the statute saying, if I don't have a will, where does my stuff go? You can say, I don't want Billy to get anything because he abandoned me when I was at my lowest, or he, whatever reason. We don't pry. We don't ask questions. Okay. And then why us? So, just do your estate planning. It does not have to be with me. It does not have to be with the Tony Law Firm. But if you do choose us, there are so many great reasons to do so. We are high quality. We are, like she said, very affordable, approximately half of the other estate planning firms in town. And then we are a small business, so you'll be supporting a small business. But I will say, just to boast a little bit, we won the Best of 352 award last year. So that was for Ocala. And our home base is not even in Ocala. So that's pretty fun. And then, yeah, I mean, if you have any questions, let me know.
So I want to. We hosted a workshop on heirs property earlier this month, and towards the end they brought up the Ladybird deed. Can you go in, which really got my attention? Can you go into the differences between go a little deeper into the differences between the Ladybird deed and the trust? The
Yeah.
pros and the cons with the Ladybird deed compared to the trust.
Yeah, so the pros and cons is 100% just dependent on what the assets are. So if you have a certain type of assets, it's not even necessarily a lot of assets. It's a type of asset. So business interest, if you own an LLC, if you have minor beneficiaries, if you own real property, it might make the most sense for you to do the trust. Whereas the Ladybird deed only covers the home. So if all you have is real property and nothing else, then that might be the best route for you, because it's the cheapest route and it's going to get what you need to get done because you don't have anything else, right? And if you do have an account, you can do pay on death beneficiary designation. So this one gets overlooked all the time. You don't have to set up a trust to avoid probate. You only need a trust if you have certain assets, and there's always a workaround. So while you have our accounts and real property, you can get away with pay on death beneficiary designations, which you would do at your bank, and doing a Ladybird deed. And it is a much cheaper alternative than going the trust route. The trust route is all encompassing. So every intangible, like accounts, real property, business interests, those end up in the trust. Tangible personal property, we don't care about, that's handled by the will. But the intangibles, so think money, essentially. Your you might want to do the trust because it just streamlines everything. It puts everything in one place so that your beneficiaries know where to find everything and your successor trustee knows what to do. But
And so you say a trust is a place where the asset, a place for the assets to live.
yes.
And so so kind of make clear the ladybird piece that if I have more than just property,
Mm-hmm.
that you probably want to go a different place, a different route. But a trust, and so if there's insurance, if there's investments, if there's retirement funds, annuities, and all that kind of stuff, um, is trust the best route, or is there another route? Can you just give directions with each thing? In
Yeah.
Okay,
Yeah. Yeah, you can go asset by asset. So, um, if you want to go to, all of your banks, so every place where you hold retirement, all the places, that you have financial assets, including life insurance, just designate beneficiaries on those. And that's a perfect workaround. And lawyers don't like to talk about it because you don't need us to do that part, right? So you just go to your bank, say, I want to designate payable on death beneficiaries, and boom, it's done. It goes straight to them. It avoids probate. So, if, like I said, if all you have are accounts and a uh, and a house, then all you need to do is pay on death, beneficiary, all those accounts, and do a ladybird deed, and you're covered. You'll be out of probate.
okay. I'm pulling my will up now. I did my will several years ago, and so I'm trying to see which one it is. It just says, where would it say it on the will, which one of these it is? Like I say, by the instrument revoke any and all former wills and codicils herefor two made me and do make them publish and declare this be my last will and testament. What does it say on here? Which type I have?
Are you referring to pour over versus non pour over?
Say it again.
Are you talking about the distinction between pour over and non pour over? What do you
I
mean
don't.
with
So I'm looking at my will right now, and I'm trying to determine. I know it's definitely not Ladybird. Um, and so I'm
Daddy,
okay?
are
trying to.
you trying to figure out if your will is maybe like if there's a trust too, or if that's like even something completely separate, or no?
Yeah, is that something separate from this will? So I have this a will that has where everything goes.
Mm-hmm.
What is that? What is that based on this the trust and things like that that we're talking about?
So there would be trust language in your will if it were a testamentary trust. Typically,
Okay.
revocable living trusts are a separate document and it'll say revocable living trust on it. A
Okay.
ladybird deed is a deed. It is a deed.
Okay.
Um,
Just like deed to the house. Okay.
yeah, just like a deed to the house, but it does not take effect. So your beneficiaries don't get squat until you die.
Okay. Okay.
I have something to circle around in my mind. How many houses, like, so I would imagine you would need to do a ladybird deed for each individual house. So at what point does it make more sense to say, well, I'm actually going to save money doing a trust because I own more than one property or
Right.
I own more than however many properties?
Probably, I would say if you own three or more, it's better to do the trust.
Okay. And then something else I want to, it just is an idea that's popping in my head. So something that I notice is sometimes you'll have like someone who they left their house to their family and it was left to the family, but there was nobody in the family that was responsible enough to make sure that the taxes got paid, so then the family lost the house.
Yeah.
So could the prevention of losing the house literally be designed in the trust where essentially like the house lives in the trust and then you can set up like, well, you know what? I want this portion of my life insurance to be in this investment. And
Yeah.
every year the money comes out of this investment just to always make sure the house pays so you can protect the legacy you built and not rely on everybody to have to keep it up. Like, can it go that deep to like where it pays house taxes and everything, and like literally, because I hear rich people, they just always have a trust, and people talk about trust babies, and that's like a thing, like everything just stays in the trust, and so they don't have to worry about are the taxes paid because the trust is paying it. Is am I thinking of this right?
Yeah. Yeah. We're actually doing one right now for a lady who had that exact concern. She was concerned that her beneficiaries are not going to pay the taxes, not going to do the repairs, not going to keep up with it. And so we are setting aside in the document instructions for setting aside a certain amount of money to be paid out by the trustee so that they can keep the property basically in the trust.
And the trustee, that's a different fee from the 3% across the board for the attorney, right?
Right. So the for us, I don't know how other firms do it, but for us, it's a flat fee. So um, for all of the documents for a married couple, so we're talking a joint revocable living trust, individual wills, um, individual powers of attorney, healthcare surrogates, individual living wills, and a deed. That is only 1,600 for full estate planning. That's 1,600. That's a one-time fee. That's all you pay. And you don't have to worry about it ever again until if you want to amend it, of course. But it can be very easily a one and done situation.
That's amazing. What about somebody like, so like me and my husband? Well, I'm asking you, you already, I know the answer, but I want to ask because I want everybody else to hear it too. But
Okay.
so like me and my husband, we have our will, living will, power of attorney, healthcare power of attorney. Like we already have all of that. So what if like really the only thing missing from our equation is the trust for me and my husband? So we can start like filling that up and organizing everything to designate to the trust. How much would it be for like just the trust if I already have all the other documents?
I wish I brought my sheet with me. I want to say it's about 400 for just a trust.
Okay.
So yeah, I mean, if you're doing it a la carte,
It's like less than half.
yeah. I mean,
Okay.
it's way cheaper to do everything at once, but if in your situation, like you said, you
You
only
already got everything
have,
else.
of course, it's going to be a lot less.
Okay. That's really affordable. That's amazing.
Yeah, yeah, he's a good dude, Scott Tony.
Yeah. Good stuff. I want to throw out some questions that I faced from like my clients, just doing like insurance and investments and stuff. Like, I run into a lot of single parents.
Mhm.
And I'm just curious, like if you have like a single parent, right? Let's say you got a single mom or a single dad, and the other parent is just like not in the life at all, or maybe they're just paying child support,
Yeah.
or just not involved at all. Can that single parent like do these estate planning documents and then even decide like designate what they would want to happen for the care of their children? Or does it like not matter what they say since the other parent is there? Like, how does that work for a single parent? Because I run into a lot of single parents that they want to do it, but they're just not sure how to work, or maybe
Mhm.
it's a maybe they're married, but two of their kids are from another parent. Could you help with a little bit of clarity on that when you have like, mixed households or single parents and they want to do this financial planning and make sure their kids are straight?
Yeah.
But
Yeah.
yeah,
It would just depend on, the parental relationship. So has the usually the father been declared, the legal guardian in some way? If they haven't, if they're just, paying child support and they're not, then you can do a single pack and just completely cut him out. That wouldn't be a problem at all. It's especially important for like guardianship designation. So if
Can can you
that parent has been declared a parent, then obviously that child would go to the other parent before it would go to the person that you've designated.
okay,
So that has come up a few times where someone wanted to do a guardianship designation, but their ex-spouse had legal custody, partial legal custody still. And so we were not able to do that for her because, the other parent would, of course, get the child.
so even though, so let's say other parent gets a child, can they create a backup to where it's kind of like, well,
Yeah,
kind of like, well, of course the other
local
parent would get the
guy.
child, but if they're not there anymore,
Yeah,
this would be the next route.
right. Exactly. Yeah,
Okay.
we can definitely do that. But
Awesome.
she
That
had
gives
just
clarity.
Yeah, she had just determined that it wasn't worth it, the
Oh,
extra money. So,
true. Okay, that makes sense.
yeah.
Okay. Any Charlie? You go ahead.
Yes. Oh, thank you, Reverend Ross, and thank you everybody for sending me an email tonight. I appreciate this. The question is for Sarah. When does a living will become a disadvantage for a very large family? For let's take for an example, my mom just turned 90,
Mhm.
and we're now into the fourth generation, and we have assets that are currently under her name. Uh, is that good, bad, or what are your take on that?
So are you asking about the living will, the end of life document, or are you asking about the last will and testament?
I no, it's the living will.
Okay.
Yeah. Go ahead.
So I would argue that it's not a disadvantage. I would in fact argue that it's a blessing to the family because you are taking that decision away from people who might, you know, you might not want to be making that decision. So by having the living will, you are telling the doctor, this is what I want. I don't care what my family wants. This is what I want. And so a lot of times the family will respect that. And of course, you have, people who will object, and of course, it'll have to go to court for a hearing. But, ultimately, most families determine that, this is what mom wanted, this is what dad wanted. So this is what we're good with.
Okay, so I just want to be clear in the communication with you. So if the wishes of, let's say if my mom is that, let's say the home property where the house is, if her will is to leave it to one of the siblings, like that youngest daughter of hers, uh, so would that have to be specific in writing in the will?
Yes. Yeah. So that would be in the last will and testament.
Okay,
Yep.
okay.
Yep. The living will is strictly that end of life document. That is the pull the plug decision that is made by your doctors. The last will and testament is the testamentary. Where does my stuff gone?
Okay, so just a follow-on question now that you answered that one. For an example, having multiple pieces of real estate that's in perhaps three, four, five different locations, uh, without the mother clearly indicating who gets what,
Mhm.
would that land then be divided by law between the siblings?
Yep. And we see it, and it is a nightmare. So I do a lot of the probates, and we have, cases like that, especially heirs property cases where you might have 20, 30 beneficiaries because this property has been hanging out forever. And by law, the intestate statute says, it's going to go to your kids usually. Well, if that kid dies, it would go to that person's kids and however many kids they have. And it just goes on and on and on. And if you have several generations of that, you're looking at a nauseating amount of beneficiaries that you have to get waivers from, you have to get consents, you have to send formal notice to. And those probates last a very, very long time because it is hurting cats. It is very, very difficult to administer those estates. You
I was
definitely,
just
Wow.
large families, you want to have a will. You gotta have a will.
I sat in on a this was something probably about a half a year ago. Advice, and I've actually included in a sermon because it made so much sense to me. To where it was advised that because most of the time people have a heart for the child that's had the most difficult life and maybe still having a difficult life, and it may be a property that they worked their entire life to obtain, and sometimes it's not in the best interest to give it to the most needy child, but more or less the most responsible child that you've had a responsibility, and they might choose to allow the one that's really struggled, but when you give it to that one that's really struggled and may still be struggling, in a couple years they might lose the home, and so the legacy that the parent tried to leave behind is now lost because you left it in the home of the one or you didn't clarify it, and now you have, you know, you got 4 children, and then 2 who died, and then they have 6 children. Now it's all split up, and then you may end up losing it because of that thing that I forgot the word that you used. And then sometimes it's best to put it in the hands of the most responsible child that you've had a conversation with to make the process a lot easier. Do you
Yeah.
agree with that?
Yeah, absolutely. And in those situations, if you were a client and we were having a consultation, I would recommend doing the trust for that specific situation, because in the trust you can spell out all the different scenarios, all the different contingencies. So if this person doesn't pay the taxes, it's going to this person. If this person doesn't live there, it's going to that person. And you can go as far as you want with it. But there is just so much control, so much flexibility with the trust, that people don't understand. They think that you have to be this wealthy, Biltmore type person to qualify for a trust, and you don't. A trust is for everybody. It's just a tool to give you control over your assets. That's it.
One of my family members told me that when their parent fast passed away, that they had stuff in the will, but the will was contested by one of, I guess, their siblings or something, but they contested it. So then in my mind, I'm like, well, is a will even 100% solid? So that's why I was thinking a trust to me seems like solid as a rock. A will, it could possibly not even go the way, like I think it would be the last will and testament could possibly not go the way it's planned. Is that like, how does that work with people contesting the will, or could the trust protect that? Like trust can't be contested, right? Or
So yeah, the trust is actually contested all the time. So that's trust litigation. It is a higher form of probate, but it does happen, and it's the same deal as the probate litigation. So you're always going to have those people who will try to say, oh well, mom wasn't in her right mind, or there are form requirements that weren't met, or there was undue influence. The list goes on and on. But as attorneys, we can anticipate that, and we have certain safeguards in place. Like, we don't let the family in the room when we're signing. We make sure that we have a discussion with them prior to make sure that they are competent, so that we can then testify later on. No, she was in her right mind. She knew what she was doing. It was very clear. And usually those cases will, nip in the bud pretty quickly, unless they have a genuine issue of material fact, like she had advanced dementia. I mean, it's tough to dispute when you have a certain level of mental incapacity, and that's usually what people will go for. They say, oh well, she's old, she didn't know what she was doing, she didn't know what she was signing. But we all are prepared for that. We all know that if they seem like they're not with it, we don't let them sign. We say, I'm sorry, we waited too late, essentially. You can't, you're no longer competent in the eyes of the law. You can't sign this. So that's how attorneys are supposed to be. Obviously that doesn't always happen, because we see that all the time. And then sometimes people just contest the will out of spite. They're mad they didn't get left anything. It is emotional for them. They're just angry. And that comes across to the court too. It's clear who has legitimate claims and who is just angry most of the time.
thank you for clearing that up. And so the conclusion I come to is like, oh wow, it's really beneficial to go through getting these documents done with the lawyer, so that even at the end, like go through law firm, you could say, no, well, we did these documents and we did our due diligence before. So okay, thank you, that brings a lot of clarity.
So,
Yeah.
Sarah, follow-up question. I'm sorry.
No, go. Yeah,
Okay,
Jackson,
okay,
go ahead.
okay. All right, thanks, bro. So, Sarah, just a follow-up question. Will the trust oversee any previous wills that has been ministered?
So that is an advanced question. So yes and no, and it depends. The famous
Okay.
where okay, so if the will and the trust are in
Because
conflict,
you never know what's out there,
yeah, no, that's a great question. So if the will and the trust are in conflict, the most recent document prevails. So the one that was last executed. Now, the will and the trust can live together in perfect harmony if there is no conflicting matter. So you don't have to, doesn't necessarily replace it. Now, if you do a will and you do another will, that will replace the formal will. But when you have a will and a trust, since they are technically different documents, they can live together, and they frequently do. We do wills with trusts all the time. In fact, we don't want to do a trust without a will, and often a will without a trust. So we usually do them together. But your will controls different things. So your will, if you don't do a trust, so if you do a pour over will, um, it only handles tangible personal property. So people are like, oh, well, what happens to my car or my trailer or my boat? That's tangible personal property. That's passed by the will. That doesn't have to go through probate. You would take a will and a death certificate to the DMV, get title changed that way. Tangible personal property. Court doesn't really care about that so much. So, I mean, I hope that answers your question. But I mean, there's so many intricacies that you would really just have a lawyer look at it if you're not sure.
Yeah,
Thank
I've
you.
seen a situation to where a will and then a new will that was contested, and then competency was the question on the newer will, and somebody kind of taking advantage of competency, and having to kind of the courts having to kind of sift that out and work that out, with the idea that this new will was created when the person was, not competent.
Mhm.
Um, and so I've seen some really ugly as a pastor and trying to help families, deal with, death, and then even the after death stuff. It gets ugly when this stuff right here is not worked out ahead of time. But when somebody is get sat down and got it in order, you can actually help your family stay together also,
Yeah,
because it gets ugly.
absolutely. Absolutely.
Sarah, follow-up question. This is Charlie again. I'm sorry I'm consuming quite a bit of
No,
your
no,
time
please.
tonight.
No.
Would be very helpful to everyone else.
But Jackson, before you ask the question, I want everybody to know that this video will live on. And so any question that's in your mind, if you don't
Okay.
answer it, there's somebody that needs to know the answer later on that won't get it
Yeah.
if you don't ask the question.
Okay. Okay. All right. Great. Thanks. So, understanding that across the South there is a large percentage of minorities and African Americans that own farmland that obviously goes back to the Reconstruction days, and that and land and property have been changed a number of times, and there is always somewhat of a lack of education and understanding of the legal aspects of how you transition uh, property from one generation to the next generation. Having said that, if you're faced with a situation where you have a large number of people, but limited information and knowledge of the conversation we're having tonight, what would be your advice or direction in terms of trying to bring a collaboration together with a large family?
Hmm. I guess I would just recommend having a consultation with an estate planning attorney. I mean, we could go over all of that with them, and usually the consultations are free. So you really wouldn't stand to lose anything from just talking to a lawyer.
Thank you.
All right. Any other
Sarah,
questions?
can you
Go ahead, Karen.
yes, Sarah, can you draw your info in the chat, and then also um I will drop your info onto the live, but if you could drop it into the chat, that would be
Yep,
awesome.
absolutely. I'll do that right now.
Is there anyone online that has any questions that you'd like to type in the chat, or really quick come on Zoom by clicking the Zoom link in the top of the comments? Anyone in the chat that has a comment or a question, or you could jump on the Zoom link real quick by clicking the link in the top of the comments. All right. And they're just a couple about 30 seconds behind us, so I'm gonna hold off. But this has been really good, and Sarah, we really appreciate you coming and speaking with our financial wellness ministry, and we want you all to look at Sarah's contact information that's going into the comments, and because we have to, as a pastor, it's one of the most it's horrible when people are hurting because of the death, but then it gets magnified when things aren't in order. And
Exactly.
you know, one way to really show our love for those that we leave behind is to have our house in order and have things in order. So that's one less thing that they have to deal with, because what happens is then they become enemies, and then
Yep.
a family that needs one another is now fractured and torn apart, and it could last for decades, even a lifetime. And so we really help our family out when we leave them with things in order.
Yes, sir.
Hey, I saw your comment in the chat, Charlie. Right above yours, Sarah dropped her email. So if you can copy that, email her, and she'll be able to give you some direction, like an individual consultation. Um, Also, I'm gonna post Sarah's info in the church, the financial wellness page as well. So I'll post it there too, and then I just posted it on the live stream too, for those of you who are watching live stream that want to, get your estate planning done. I definitely like highly recommend Sarah. I have talked to like multiple estate planners, and I feel very good about this recommendation. I already had some of my stuff done, but I that next step of getting the trust, I got clarity from Sarah about that, and I'm super excited to get my trust from her, and just just organizing things for the future. So, Sarah, do you want to say any final words or anything before we close out the meeting?
One thing. So the biggest myth in estate planning, don't fall victim to it. If you have a will and you haven't done anything else, so you just have a will that says Billy gets the car, Sally gets the account, and you haven't set up a trust or done your pay on death beneficiary designations or done your ladybird deed, any of that, your estate will still go to probate. So be very careful about that pitfall. A lot of people think just because they have a will, they're not subject to probate, and that's just not true. So the will just tells the probate court what to do. It doesn't avoid the process. So I did want to make that very clear. And if you want more information about that, please email me, and I'd be happy to talk to you about
Yeah,
it.
Lillian has a question, and now your last comment made me have a question. Would I be able to, so when I come to you to get my trust and stuff done, would I be able to bring to you, like 'cause me and my husband, we already have our will, living will, power of attorney, healthcare power. Could we bring those documents with you as well? And you could
Yeah,
even
we
give us
asked for
advice
that.
and say, hey, this is good, or you know what? I really think that they should, like, it's kind of missing this, or this could be
Oh, yeah.
we could bring those too.
Oh, yeah. No, we
Okay.
require it. So if you had estate planning done in the past, we need to see it. So we need to see what you've already had done. We need to see what's already covered to better advise you.
Okay. Yay. And then Lily has a question, my beautiful friend Lily.
Yes.
Thank you, everyone. This was amazing. Um, would would having a trust eliminate the need for appointing someone as the executor of the whole process? Um, so my parents are going through that process, and they insist to for me to be that person, and I really don't want to be in the middle of all
Yeah.
that. I'm the middle child, and my siblings already thinking I'm, on favor for everything, and I know it's going to create a situation. So I want to give them that guidance so they can decide, what's best.
Yeah, so yes and no, my favorite answer. So yes, so if you do the trust and you don't have to do probate, you don't need the executor, you don't need the personal representative, you don't need the probate person, right? But you do need the successor trustee, which is essentially a very similar role. There, you're still administering assets, you're still overseeing everything, but it just shifts the role a little bit into something more private. So as opposed to probate, you have the judge, the court looking at you and judging everything that you have. This is a private situation. It's just with the family. It doesn't get published, and it makes things a little bit easier because you're not being scrutinized essentially. Um, I would, if I were you, I would much prefer to be the successor trustee of a living revocable trust than I would be personal representative of an estate.
Okay, yeah, makes sense. Thank you.
Yay! So we are gonna go ahead and end the meeting. Before we do, Sarah, I just want to say thank you. Thank you for just giving us some of your time and all the knowledge and answering all our questions. We really appreciate it. This was very enlightening, like super
Good.
insightful. So thank you so much, Sarah. I appreciate it.
Well, thank you for your kind words, and I'm not going to charge you if you want to ask me questions. I know lawyers get a bad reputation. We do not do that. So just reach out. I'm happy to help anyway.
All right, wonderful. I want to thank everyone for joining us. Everybody that joined us on other platforms, make sure you share this post, get this information out there. It's important that we're financially literate and that we make decisions that'll aid us in leaving a legacy for our children's children, an inheritance for our children's children. So thank you so much for joining us. And Sarah, we thank you. Kiera, you're doing a wonderful job as the coordinator of our financial wellness ministry. And everybody that's on, we thank you. God bless you and have a great one.
Thank you so much.
God bless everybody. Good night.